Hello, everybody. My name is Joey Barnett, and you are listening to Chatting with Charlie EB5 Investor Outlook, put on by WR Immigration. Today, we're going to be talking about the EB5 program, as we do every month, and you should definitely subscribe to our channel on YouTube if that's where you're listening. We get thousands of viewers every month. And it's my honor to be presenting today with Mr. Charlie Oppenheim. We've been doing this now for a few years, and it's incredible because he has a unique perspective based on his history working with the State Department and ability to kind of read the tea leaves as it relates to the visa bulletin. So we're very, very honored to have Charlie part of our team and to give us the insight. And Charlie, I'm looking forward to seeing you next week at the IIUSA conference in Houston too. So it'll be nice to see you in person as well.
Yeah, I think it's going to be a great conference.
Excellent. Well, today we are going to be talking about the May Visa Bulletin. We have a pretty veteran crowd of folks who are here, so we're going to be getting in depth on some of things, but we're also going to be talking about sort of EB5 101. At least at the end of it, we're going to be doing a little bit of a teaser for another event that we're going to be having for EB5 investors, specifically to take advantage of the current priority dates for the reserve categories. And what we're going to be talking about today is, well, how long are those categories going to be remaining current? And what will USCIS need to do in order for final action dates to be imposed? And of course, nobody can give us predictions better than Charlie. And so that's why you're listening to us here today. Let me just go through our initial slides that we have. Here are our beautiful pictures. Charlie is our Director of Visa Consulting. I have been doing EB5 for just about 15 years now, and I'm a partner at WR Immigration. This does not constitute legal advice, but we would be happy to talk with you about your EB5 questions. So please feel free to reach out, visalaw@wolfstorff.com, jbarnett@wolfstorff.com. We'd be happy to help you. WR Immigration, we are a full-service immigration law firm. We have almost 200 staff members at this point across numerous offices, and we are really at the cutting edge, in particular on EB5. EB5 has been remaining very, very popular, and that's because it is current. And this is our roadmap for today. And let's just jump right into it. I see no reason to wait. So this is Chart A in the Visa Bulletin for May of 2025. And Charlie, what happened in May in Chart A?
We saw the China date held where it had been at April, but we did see that India retrogressed for a second month in a row, which was very surprising to me. I would have expected the State Department to establish both the China and India date when they originally retrogressed both in April. I would have expected that to be kind of a line in the sand that would hold number use within the allowable limits. And then if they saw, okay, the India number use was lower than expected, then they could have moved the India date ahead. But I never like to kind of, quote, rip the Band-Aid off two times. I like to do it, have a line in the sand, a worst case, and then in a best case scenario, the date may be able to advance later in the year.
Do you think they got additional information that would have caused further retrogression that they didn't have when they did the April Visa Bulletin?
Yeah, my guess is that it looked like the March number use, they expected it to be higher because they established the April dates in early March. So they must have made estimates on how many numbers are going to be used in March, and their estimates must have been much lower than what was actually used, requiring them to retrogress. Again, the retrogressions were imposed in an effort to hold the number use within the allowable per country and overall annual limits.
Exactly. And maybe we take a 30,000-foot view from that, and maybe you can just back up for someone who is new to the Visa Bulletin or new to EB5. Maybe they understand EB2 because they've been stuck in it for a very long time. But can you just explain what you mean with like the per country caps and then the annual limits and how that kind of gets broken down?
Sure. In the unreserved categories, the fiscal 2025 annual limit is approximately 11,500. And based on that, any independent country would have been entitled to a maximum of 7% would be the per country limit, which comes out to about 850 numbers, which could be used by China, India, any country in the world. Then they could have also made an estimate of how many maybe other unused numbers. So they would have subtracted the 850 China and the 850 India from the overall 11,000 limit. And then they would have also subtracted from that how many they estimated the rest of the world was going to use. And if there was a balance left over, those numbers could then be considered otherwise unused and would be made available strictly in priority date order. Typically, that means all the extra numbers have gone to China. Evidently, their estimates of rest of world demand were incorrect, and they realized that, and they had to retrogress both the China and India dates for the month of April without having provided any advance warning. That's why I think they were caught basically completely off guard by what was happening, and they had to shut down number use. So again, there are per country limits, and this is the same. You mentioned the people stuck in the lines in employment first, second, and third. The per country limits would also apply to those categories. And that's why you're seeing such limited movement in most of the other employment category dates.
Thank you. And why we will likely be seeing final action dates in the set-asides at some point in the not too far distant future. And we're going to be talking about that next. But before we do that, I just want to ask two more questions for you, Charlie. So would you think that there would be no more unreserved visa issuances in Guangzhou or Mumbai or in India for the rest of the fiscal year?
Yes, I originally mentioned that the per country limits were approximately 850. China, through February, has already used over 3,000 numbers, far exceeding their per country limit. But that was because the State Department had previously estimated that there were going to be otherwise unused numbers. Those went to China, allowed that number. Then they realized, okay, we don't have as many unused. And therefore, basically, China has been shut down for the rest of the year. India has some numbers remaining available for use during the month of April. And evidently, they feel maybe some numbers for May.
Right. And when we look at the statistics that the Department of State posts about the monthly visa bulletins for India, I think it's under 500. We were just looking at it. I think it's under 500, but that doesn't consider any adjustment of status applications that were filed by Indian nationals in the United States, which I imagine is a substantial amount. I mean, at least in the couple hundreds for sure. I don't think that would be
exactly
too crazy to assume.
Yeah. And that's one of the things. At least we have some visibility in terms of number use from the State Department. It would be extremely useful if the USCIS were a little bit more transparent and allowing the publication of number use in terms of adjustment of status number use. Because as you said, the amount of Indian applicants being processed in the U.S. is likely to be very high.
Right. And we don't know that for fiscal year 2025, right? We still don't even know for fiscal year 2024 because they haven't released that table 5, the annual report by the Department of State, which is where we've always been able to kind of see number usage compared to visa issuance, right? And the difference is the adjustment of status.
Correct.
Right. Okay. So the other question I wanted to ask before we moved on to the set aside or reserve categories is, does this unreserved retrogression or final action date impact the ability of somebody post RIA, a new EB5 investor, to file an EB5 case today in the set aside categories?
No, this strictly the unreserved categories are those that had filed prior to the Reform and Integrity Act having been published. So this is strictly on the unreserved applicants. It has no impact on the RIA applicants who have applied in any of the 3 reserved categories.
I guess it could apply to a Chinese who's not applying in a set aside or an Indian who's not applying in a set aside, but those are few and far between. Okay, so the set aside categories, again, remain current, which means that people in the United States can file an adjustment of status, and along with that, an EAD and an advance parole to get the interim benefits during the time in which the adjustment is pending. And the adjustment will be remaining pending until the I-526 has been approved, and at that time when a visa becomes available. And so those interim benefits allow people in the United States to get, I guess, benefits of having the green card before they even have the green card, because they're in the United States. They get the unrestricted work authorization, where they can work for any company they want or start their own company or just hang out on the beach if they want to. And they also have the ability to travel with advanced parole, although you can expect to be put into secondary inspection on your way back in these days. And we really are advising clients these days to avoid international travel unless it's absolutely necessary. And, if you do leave, it really should only be for a short-term trip, and you should show ties to the United States when you come back in. And that's something that we're helping a lot of clients with, because after the administration change, this has been a change at the airports, and people have been sort of getting mixed up with CBP there. All right, so this is chart A. Chart B, maybe just first, Charlie, what is the point of chart B?
Chart B, typically the dates for application filing dates are established and posted in the October visa bulletin, with some minor adjustments throughout the year. But basically, the major changes are announced in October. They're announced in order to generate additional demand so that the annual limits for the specific year can be reached. So when state published these unreserved application filing dates, they thought they needed plenty of people within these dates to file so that applications at adjustment of status, they could be worked on, so that if the applicant's priority date was reached by the final action date, say several months later, the case would be ready for immediate action, instead of only allowing the applicant to file at that time and then take months and months to get processed.
Sort of priming the pump.
Established. Yeah, these dates reflect where state had expected the dates to be 8 to 12 months down the road, no later than September of 2025. As we've seen with the retrogressions in the chart A, these dates were very exaggerated and overestimated what could be done.
And importantly, chart B can also now be used in terms of child status protection lock-in, at least for USCIS. So that's good to hear. All right, so let's keep moving through it. This just shows the retrogression in the unreserved category. In April, it went back for both China and India. And then in May, it continues to go back for India. And that's what we've been discussing for the past 5-10 minutes. This was in the footnote of the May 25 visa bulletin. What is this saying here, Charlie?
Basically, this is explaining why for a second month in a row, the India date has retrogressed. In an ideal world, this type of notice would have been published in January, February, at the latest March, to provide advance notice that the dates were going to retrogress for and why for the month of April. And again, now this is being done to indicate why they retrogressed it a second time for India. The important thing here is the note that there may be a need for the establishment of a rest of world final action date. That would be the first time there's been a rest of world final action date in the unreserved category. And as a caution for everybody listening, I would expect a date to be announced for June. If it's not for June, that would be great, but I would be planning my life accordingly, that there's going to be a rest of world unreserved date for June. I think that this is indicated by the fact that they had to retrogress both the India and China dates because there weren't going to be as many unused rest of world numbers as they expected.
Wow, that's really unexpected, something very new. And you would say that likely happened because they underestimated the rest of world demand, which allowed the numbers to go to China instead. And because of that, it may be required to implement a final action date so that the overall annual limit for the unreserved does not get reached. Do I have that right?
Correct. Yes.
Excellent. All right. Well, the Department of State will be continually monitoring this, and so will Charlie and I. So please stay tuned and keep your eye out for every visa bulletin. It's always a changing world, and you need someone to be able to guide us. Thank you, Charlie. I don't think anybody else really could be able to understand that rest of world final action date comment. And so I'm glad you were able to clarify what could happen. All right. So what are your takeaways from the visa bulletin here?
As the first bullet says, I would expect the 3 reserved categories to remain current through September. The reason for that is there just would need to be too many, for example, in the rural and high unemployment areas, there would be too many approved petitions required to reach the limits. I just don't see that happening, which is a good thing for those that are able to continue to file and take advantage of the concurrent filing program. This is a great benefit, concurrent filing, because then anybody that has filed under that, if a final action date is ever imposed, then they are covered and they can just sit back and wait for their turn to come up.
Sorry, Charlie, let me just butt in there for one moment. And I do think that's really important because in some senses, your investment for EB5, people are talking about, right, Charlie, like, well, am I going to do rural? Am I going to do high unemployment? Am I going to be stuck in a backlog? I'm speaking specifically about Chinese and Indian nationals. Like, how long is this wait going to be? And for those who are in the United States who can file the adjustment of status today for either high unemployment or rural, you're still able to remain here and get that EAD and get that advanced parole, no matter which category you go in. And yes, there is likely a difference in the wait time until you get the conditional green card. But until then, in the interim, you are covered and treated the same way. So sorry, I just wanted to make that point because it's something that people ask often. Sorry, please continue.
Yeah, and that's a great point. And it is also important to remember it is the final action date that applies in the month your case is ready for final action, not the date you filed. So although the categories are current for the month of May in the visa bulletin, if there is a final action date when your case is ready for final action, say in October or November, whatever the date in the bulletin at that time is governing whether your case can be finalized at that point. So again, it's not what it was when you filed, it is what it is when your case is eligible for final action. In a worst case, I think that high unemployment final action dates could be imposed and possibly rural as early as October. That's the first month of fiscal 2026. That's when there is a brand new supply of numbers. And I think that, as it mentions, this is a worst case because I think it's going to require a lot of approvals to have been processed to conclusion in the coming months. And based on what we're seeing now, that may not be happening. In terms of a best case, for final action dates would not need to be imposed for high unemployment or rural prior to January of 2026. And again, that's based on the petition processing. I don't think that there's going to be enough petitions available for final action until that time. And it's important to realize that the State Department should only impose a final action date when the amount of numbers which have already been used and the numbers which will be used in the coming months will exceed the annual limits. So again, I think we're in good shape based on what is happening right now. But again, my projections are based on the best information now available in April for what may happen in October and beyond.
Right. And we're going to get to the specifics here in terms of like how USCIS needs to process and things like that. But I think I can confidently say at this point that if you're a Chinese or an Indian national who's filing an I-526 today, there will be a final action date at the time that the I-526 is approved, based on what we are seeing with processing times anywhere from 10 to 24 months, right? By that point, I think we will likely see a final action date, and there will be a period of time in which you will have an approved I-526E, and you are looking at the forward movement of that final action date in the visa bulletins for the upcoming years. So what will happen when these rural and high unemployment final action dates will be imposed? Because we knew that this was going to happen at some point when the Reform and Integrity Act came out, and we saw what was going on with kind of like the carryover and the waterfall and the low per country limits in each category. We knew this was going to happen. So now we're kind of getting to that point. And I'm not saying people are late at this time because it is still current, but there is a line. And so can you kind of explain that last bullet point?
Yeah. As you mentioned, it's always important to act in a very timely manner because you want to be as close to the front of any line, which it will develop. And there is no reason why there should not be enough approved petitions in 2026 at some point to require the imposition of final action dates for both rural and high unemployment. We've already seen, based on the amount of petitions filed, and again, USCIS should have finalized action and approved sufficient amount to use all available numbers in 2026. Therefore, I believe that there will be final action dates imposed on China, India, and I believe there will be rest of world final action dates. It is very possible that both the China and India dates may be the same, with the rest of world date being much closer to the current actual date. And it is very possible, because of the per country limits that will be imposed, that there may be 2 or 3 other countries which would be added to the list, which would have a final action date governing their number use. And again, that would be because of the per country limitations.
Right. So that's very sobering to hear. But for those who are in rest of world, there is some relief, right? Even if there is a final action date imposed because of the dual approval codes that USCIS puts on the I-526 approval notice. And that allows people from rest of world to use numbers in the unreserved visa category, which remain current, at least for the time being, in the visa bulletin. And I'm just going to go back to that slide where it says all chargeability, 5th unreserved, that's current. That would allow individuals from rest of world who could be subject to a final action date in the set aside categories in the future to use those numbers as well. Now that will take away numbers from China and from India for pre-RIA, but that's how they have set up the system. Anything else that you wanted to mention about takeaways before we go through? There was a lot here that I think people may not have really understood when they first saw the visa bulletin that you're now raising, including the likelihood of final action dates for everybody, for reserved and unreserved at some point, right? I mean, that's kind of potentially what we are seeing because of that footnote and because of the State Department's underestimation of rest of world demand.
Yeah, and in terms of the final note at the very bottom, in terms of the applicants being able to opt out and change and be processed in the unreserved categories, there is no need for them to be doing so at this point, because all of the reserved categories are current. People would be taking advantage of this opt-out procedure once it becomes evident that there is going to be a rest of world final action date. Until that time, there is really no need. They can just be processed as rest of world in the reserve categories.
Yeah, right. Okay, so let's continue. So this is, I think we've had this up in the past, but this is sort of a theoretical calculation of whether a final action date will be imposed, right? So I kind of want you to walk us through this, Charlie, and then we're going to go through it for what it may mean for rural and high unemployment.
Right. What the State Department knows for, and we'll use the unreserved categories as the example. Say that the annual limit is 11,500. What they would have done is looked, okay, we're getting ready to make the determination of the April dates. We're going to look at how many numbers have been used October through March. They would subtract that from the 11,500. They would estimate that a certain amount of numbers are going to be used in April. They subtract that out. Then they base on their new final action date that they are considering. They would make an estimate, okay, how many additional people might require the use of a number in the remainder of the year. And if they see that that total is going to exceed the annual limit, then they would need to impose a final action date. At this point, in the reserved categories, they're seeing that the previous month's number use, the current number use, and projection is what'll be used the remainder of the year in the reserved is not going to exceed the limits, so they don't need to impose a date for the reserved categories.
Excellent. And now let's kind of talk about what that means theoretically for whether a final action date will be imposed in the rural category this fiscal year.
Yeah, this is a little bit easier. I know that what I just went over is a little bit maybe hard to understand, but this is the theory behind. There are quarterly limits for the first 3 quarters and then the final quarter. So the first 3 quarters, in theory, State Department should use only 27% of the per country limit, and that would be 81% through the first three and 19% remaining for the final quarter. So if they saw the amount of numbers were going to be equal to or exceeding 1,192 numbers having been used by rural applicants October through December, they would have imposed a final action date. They did not see that, so they left the category current. Their next benchmark, what they said, okay, by the end of March, will we have used over 2385 numbers? They once again said, nope. So there's no final action dates. They move on when they're going to be doing the June dates. They go up to 3577, still not enough applicants to use the numbers. They leave it current. And it's estimated that the rural annual limit is going to be 4,416. If they are not going to exceed that limit of numbers being used through September, they will leave the category current. And that's exactly what I think will happen. It would be great if we could use 1,000 numbers. I do not see them using at the current rate over 1,000 numbers, but that's strictly based on overseas number used by the State Department, having no idea of how many numbers are being used by USCIS. So we'll see.
Right. And just to be very clear about this, we are not even at 1,192 rural visa numbers being used, not even close to that through February.
Yeah.
Right. And we don't know adjustments, but I'm just assuming, it's a very low number right now. And so that's why we're unlikely to see it. We're just not getting enough adjudications by USCIS to show this demand. Now let's go to high unemployment, where they have half the numbers, right? 20% for rural, 10% for high unemployment.
Yeah. So again, they're going to look at their projections for the number use through each of the months. 596. They knew they weren't going to do that. They weren't going to reach 1192. They now have made the estimate. They're not going to use the 1789, and they won't use the 2208. As you mentioned, overseas number used by the State Department, I think it is less than 75 numbers through February in the high unemployment area. So it's inconceivable that they would be able to use enough numbers by the end of the year to require a final action date. And these are the same type of this step. And for the rural, this is the same kind of basic in theory behind when they would be establishing dates in fiscal 2026. They would follow the same type of example. And this is why I don't think they're going to have enough approved petitions to require the number use in the first quarter, October through December. In the second quarter, which would be January through March, they are likely to have enough numbers by then. There is no reason to believe they won't have enough by the third quarter, the October through June limit.
And one thing I should also note here is that because of the way that the annual limits have kind of decreased over the past couple of years in general, so will these overall limits, right? So the supply is getting lower. It's not going to be as many as the 2208 next year for high unemployment.
Correct. I would expect next year's limit for high unemployment area to be in the 2,000 to 2,100 range.
Okay. Well, this is great news if you're trying to get your EB-5 application in. Not great news if you're worried about how long the backlog may be, because we just don't have the visibility. We are litigating a FOIA right now. We're trying to get data through the end of 2024. I do know that AIIA is also trying to litigate and trying to get data even further into 2025 to show a breakdown of I-526 filings based on country of birth and based on visa category. Right now, I think we're going off of data that's almost 8, 9, 10 months old. And so it's hard to estimate. Once we get that, I think we'll be able to advise a little bit better for what wait times could be potentially for someone who is filing today. Charlie, thank you so much. I really appreciate you giving us that insight. I think there was a lot to take away here, and I really appreciate it. I know everybody in EB-5 appreciates your insights. So thank you so much. We have some questions. Let me do some questions before I get into this next teaser here. Oh, hi, Shashi. We had a great question from Shashi. Charlie, what happens to the unused visas in the reserved categories in a fiscal year?
Unused numbers from, for example, any unused reserve numbers under the 2025 original limit can carry over for 1 year. So those unused numbers from this year's limit would carry over and be added to the 2026 limit. By the same token, reserve numbers that were unused under the 2024 annual limit were added to the 2025 limit. If any of those numbers which remain unused, since they can only be carried over for 1 year, if they remain unused at the end of that year, the following year, they go to the unreserved category. So unfortunately, unused numbers are wasted in terms of the reserved applicants. And there have been thousands and thousands of reserve numbers, which literally have been wasted since the inception of this program, that will be in the future detrimental to the processing of reserved cases. But on the flip side, it has been very beneficial to the applicants in the unreserved category who have benefited by having their annual limit increased dramatically.
And that reminds me, we do have like this waterfall diagram, and I will include that in our chatting with Charlie next month for people who want. We can dive into that a little bit more. Here is a case specific question, but I'm still going to answer it. Charlie, is there a possibility for unreserved India to have a final action date October 2019? Do you think this fiscal year it's going to be current for someone who filed in October of 2019? I think we answered that before, but yeah, the answer is
no. Unfortunately, in theory, they should not have another retrogression, and I would not imagine that they're going to advance the date. The fact that they retrogressed for a second time means that they underestimated when they set the original date. So if you have a date on May 1st or beyond of 2019, you're basically out of luck until October, the first month of the new fiscal year, when they have the new supply of numbers. And I would mention that I would expect the State Department to try to recover from both the China and India retrogressions as quickly as possible in October and the subsequent months, because they know that they want to try to take care of cases that were potentially pending and just waiting on numbers. So again, they will try to have as much of a recovery for October and going forward in fiscal 2026.
That's a very good point. I'm glad you brought that up about how it's going to likely advance in October when we have the new annual limit. Here's a question about the Child Status Protection Act. Is there any State Department policy or guidance as to whether an EB-5 dependent would age out if the child is 20.99 years old on the date that the EB-5 visa becomes current? If they're under 21 at the date that the EB-5 visa becomes current, I would argue that there probably is no age out, because you can subtract the amount of time. Well, she's under 21 and you can pay the fee bill or file the adjustment on that date, and you can subtract the amount of time that the I-526 was pending under the Child Status Protection Act. So I think that person would not age out. That's my thought, but give me an email and we can talk about your specifics. Okay, I don't see any other questions at this time. This was a slide that Walter Ginden from Can-Am put together when we were on a panel for an AILA EB-5 webinar, and I thought it was really good, and I thought it breaks down the relationships of the different entities in EB-5. For those who want to learn, I find this to be very important because there are a lot of different entities involved with EB-5, and it's hard to understand where exactly your investment is, what company you're the owner of, what rights you have, and what decisions you can make, and who's in charge of the EB-5 project. And so the first thing that I want to say is that you don't invest in a regional center. You invest in a project that is sponsored by a regional center. A regional center allows a new commercial enterprise to pool money from a number of EB-5 investors and provide that as financing to a job-creating entity which creates the project. You, the EB5 investor, are an equity owner of a new commercial enterprise. Generally, you are a member or a limited partner, and there is a manager or a general partner that runs the day-to-day operations of the new commercial enterprise. And we call that the NCE in EB5 world. So you are an equity owner in the NCE that is being managed by a general partner. And the purpose of the NCE is to provide the financing to the job creating entity, or the JCE. Now, the JCE can be an affiliate of the NCE. The JCE can be a third party unrelated to the NCE, or I should say the general partner. And it's also possible that the JCE is affiliated with the regional center and the NCE. And so there's different regional center models out there. People do it differently. Sometimes regional centers do their own developments and they manage the new commercial enterprise, and it's a very vertically integrated model. There's other models out there where there is a regional center operator that does projects around the United States. So they affiliate with different regional centers based on their geographic designations, and then partner with them, with that regional center, and file that 956F in order to raise money for the development. Now, that development may be the JCE, that could be somewhat affiliated with the general partner, or maybe it's a third party. Again, there's nothing in EB5 law restricting any of that. If they are affiliations between the JCE and the NCE or regional center, there are some additional protections in the Reform and Integrity Act for investors, because the government was trying to manage that, I guess, potential conflict of interest. That's why they have fund administrators. That's why they have separate accounts now. That's why they are doing all of these regional center audits. Oh, and that's something that I also wanted to mention. Oh my God, I'm undergoing 3 regional center audits in the past 2 months by IPO. And if you're operating a regional center, you need to be prepared for these audits. And by that, I mean, you need to have a very robust record keeping system. They want you to walk them through your system, and they want you to be able to track investor funds, track investor signed agreements. They want a system in place, and then they're going to say, hey, I want to see X members who, X investor who is a member of this NCE. I want to see that subscription agreement. And then you'll have to be like, okay, here it is, walk you through how to find it. That type of thing is something that every regional center is going to have to deal with at some point in time. And we've helped a couple of them already go through that process. All right. So back to this, though. The job creating entity is, I think, the most important aspect with EB5, because it has to do with the job creating. And that's the main part of EB5 eligibility. But all of these are very important. And when you're doing your due diligence, you need to be looking at all of them. If you have a great job creating entity, but a regional center that doesn't know what they're doing, or a new commercial enterprise that doesn't know how to track the funds, or has conflicts or something along those lines, then maybe it's not the right EB5 project, even if the developer is very successful and has a great track record. On the other hand, you don't necessarily want to be going with a regional center that potentially has a notice of intent to terminate. Are you making sure that they're paying all their fees? There are different compliance things that each one of these entities has to play. And it's on you as the EB5 investor to kind of go through it and understand what these relationships are and how you are best protected. And I guess the last thing I'm just going to say on this is the relationship between the new commercial enterprise and the job creating entity. That's where you want to analyze the financial risk, in as much as you want to be analyzing, is this job creating entity going to be successful? What is their exit strategy? How are they going to create the jobs and repay the money? Well, part of the repayment of the money is the types of investment that you're making. Is it a debt investment? Is it an equity investment? Is it secured debt? What is it secured by? What is the value of the collateral? Is there somebody else in front? Or are you the mezzanine? Or are you the senior? All of these are different for the project. And so that's the type of analysis that needs to get done. in terms of, hey, am I going to get my money back? And I always note to EB5 investors that in EB5, getting the money back is not an immigration requirement. You're required to make an investment. You're required to sustain that investment, but you can get the full immigration benefit and lose the money. That's obviously not what anybody wants. And so there is this financial investment side of EB5 that sort of goes above and beyond the immigration requirements that is very important to people. You know, this is a lot of money and they've worked hard for it and they expect to get it back. And, you know, there are different projects out there, different levels of risk, and it's up to you as the investor to kind of do your due diligence. As an immigration attorney, we help advise as it relates to immigration risk, EB5 compliance, regional center reputation, that type of stuff. But you can have all of that check the mark and the project still not repay the money. So yeah, your funds have to be at risk, and there is an element of risk with EB5, and you need a good advisor to help you make those decisions. All right, so I guess I'll get off my regional center soapbox. Thank you so much for listening in today. If you guys do have questions, please feel free to reach out. Here's our QR codes for all of you listening on YouTube. Feel free to reach out at any of these ways. Here's my email, jbarnett@wolfsdorf.com. Here's all of our office locations. Thank you so much for listening, Charlie. Thank you so much for your insight. It was really wonderful, and I'm looking forward to seeing you next week in person.
Yep. Been a pleasure.
All right. Take care, everybody.